Faculty of Law by
Gonzalo Ulloa Terán.
Law and Justice Around the World.
1200 legal lectures about
Professional Translation Services, GUT.
The American Anti-Corruption Act.
Professional Translation Services GUT presents
The American Anti-Corruption Act. Constitutionality. Is the American Anti-Corruption Act constitutional? In short, yes. It was drafted by some of the nation's foremost constitutional attorneys. This document details each provision and why it passes constitutional muster. May 2016. 1. Conflicts of interest. Prohibiting paid lobbyists from making and bundling contributions. The AACA prohibits paid lobbyists from making campaign contributions and from bundling campaign contributions. Provisions of the American Anti-Corruption Act. 1. Stop conflicts of interest and political bribery.
Provision 1. Prohibit politicians from raising funds from lobbyists.
Members of Congress and candidates for federal office may not accept contributions in connection with an election for federal office from a lobbyist.
Provision 2. Prohibit lobbyist contribution bundling.
Prohibit lobbyists from bundling campaign contributions in connection with an election for federal office.
Provision 3. Close the revolving door.
Extend the existing revolving door limitations applicable to members of Congress and congressional staff to 5 years for former members, and 5 years for former congressional staffers who are either 1. Paid at a rate of 75% or more of a member's salary, or 2. Whose duties are not primarily secretarial in nature. Prohibit members of Congress and senior congressional staff from negotiating or having any arrangement concerning prospective private employment, including engaging in any preliminary or exploratory discussions regarding such employment, while a member of Congress or senior congressional staff.
Provision 4. Prohibit members of Congress from fundraising during congressional working hours.
Prohibit members of Congress from engaging in political fundraising and soliciting between 9 a.m. and 6 p.m. on any day in which their House of Congress is in session and is not adjourned or in recess for that entire day, and during any other hours in which the member's House of Congress or any committee or subcommittee thereof of which they are a member is conducting business. 2. End secret money with full transparency. Provision 5. Require full transparency of significant political fundraising and spending. Require automatic electronic disclosure of political fundraising and expenditures over $200. Enact the Democracy is Strengthened by Casting Light on Spending in Elections, Disclose, Act of 2015, S. 229, H.R. 430, 114 th Song, to end dark and gray money. Require disclosure of bundlers of contributions. Require incumbent federal officials and candidates for federal office to disclose the identity of any individual who was authorized by or known to the official or candidate to collect and transmit contributions to their campaign committee or leadership PAC, regardless of whether or not the individual is a lobbyist. 3. Fix our broken elections.
Provision 6. End gerrymandering.
Transfer all authority over redistricting to an independent, fully transparent commission that must follow strict guidelines to ensure accurate representation for all voters, regardless of political party.
Provision 7. Change how elections are funded.
Give each registered voter a small credit they can use to make a contribution to candidates and PACs that agree to fundraise only from small donors. Allow PACs that accept only donations from natural persons no larger than $100 to make contributions to candidates 10 times larger than the current limit on traditional PACs.
Provision 8. Let all voters participate in open primaries.
Make all candidates for the same office compete in a single, open primary in which all registered voters may participate. The 4 candidates with the most votes will proceed to the general election. On the primary ballot, allow candidates to display their party preference, and allow parties to display their chosen nominees. Establish meaningful thresholds for the number of signatures required to be collected by volunteers in order for a candidate to appear on the ballot.
Provision 9. Let voters rank their top candidates using ranked choice voting. Avoid spoilers.
Use ranked choice voting in all elections so voters may rank candidates in order of preference and not be concerned about voting for spoiler candidates.
Provision 10. Reasonable term limits.
The Act sets reasonable term limits of 18 years total at each level of government, so that candidates focus on public service instead of staying in office.
Provision 11. Automatically register voters.
Automatically register eligible citizens to vote, or update their registration, when they interact with government agencies, at the DMV, getting a hunting license, applying for food assistance, or signing up for the National Guard. Citizens can always decline to be registered. Enforce the rules.
Provision 12. Fix the FEC's coordination regulations.
The FEC's current coordination regulations permit extensive collaboration between candidates and supposedly independent super PACs. Amend the Federal Election Campaign Act to create reasonable presumptions of coordination under which an expenditure made by a super PAC is treated as a contribution to the candidate.
Provision 13. Increase lobbying disclosure and enforcement.
Ensure that paid lobbyists are identified. Current law turns on 2 requirements to trigger lobbyist status: 1, 2 lobbying contacts, and 2, 20% of time for clients spent engaging in lobbying activities. Instead, set the threshold as 1, 2 lobbying contacts or providing strategic advice to lobbying efforts or directing or supervising the provision of strategic advice to lobbying efforts, and 2, 12 hours or more spent engaging in lobbying activities. Require electronic disclosure of the specific officials, offices, committees, or subcommittees contacted, all entities, contractors and subcontractors, employed or retained to engage in lobbying activities, along with description of such lobbying activities, and the identity of each former covered official employed or retained by the registrant who engaged in lobbying activities on behalf of the client, along with description of such lobbying activities. Do away with Internal Revenue Code reporting option for lobbying expenses. Any person or entity failing to come into full compliance with the requirements of this Act within 1 year after being identified by the Comptroller General as non-compliant shall be prohibited from engaging in any activities that would require the person or entity to be a registrant or a lobbyist for a period of 2 years.
Provision 14. Fix the FEC and strengthen investigative and prosecutorial powers.
Enact the Federal Election Administration Act of 2016, S. 2611, 114th Con. The Act would replace the failed Federal Election Commission, FEC, with a new 5-member Federal Election Administration, FEA, empowered to find that violations of law have occurred and directly impose civil penalties. The FEA would, like other enforcement agencies, use impartial administrative law judges to hear and decide campaign finance enforcement proceedings. Enact the Public Corruption Prosecution Improvements Act of 2012, S. 401, 112th Cong, sponsored by Senator Leahy, Democrat Vermont, and Senator Cornyn, Republican Texas. The Public Corruption Prosecution Improvements Act of 2012 was included in the Senate-passed version of the Stock Act, and was based on an identical bill passed by the Senate Judiciary Committee. The American Anti-Corruption Act. Constitutionality. Is the American Anti-Corruption Act constitutional? In short, yes. It was drafted by some of the nation's foremost constitutional attorneys. This document details each provision and why it passes constitutional muster. May 2016. 1. Conflicts of interest. Prohibiting paid lobbyists from making and bundling contributions. The AACA prohibits paid lobbyists from making campaign contributions and from bundling campaign contributions. Constitutionality. A ban on contributions to federal candidates by paid lobbyists is likely to be found constitutional. The Fourth Circuit recently upheld a North Carolina law that completely prohibits contributions in any amount from lobbyists in Preston v. Leak, 2011, recognizing that the fact that recent corruption scandals in the state involved lobbyists justified an outright ban. And the Second Circuit also recently issued an opinion suggesting that contributions by lobbyists can be prohibited if recent corruption scandal involved lobbyists, in Green Party of Connecticut v. Garfield, 2010. Given that public perception of lobbyist contribution activity is highly negative, and that the country has in recent memory experienced scandal involving lobbyists at the federal level, a prohibition on lobbyist contributions would likely be upheld by the Supreme Court. Moreover, a prohibition on lobbyist contributions would mirror the long-standing federal prohibition on contributions by government contractors. This prohibition has been in place since 1940 and was recently upheld in 2015 by a unanimous en banc D.C. Circuit, Chief Judge Garland writing. The Supreme Court declined to review. Wagner v. Federal Election, 2015, denied Miller v. FEC, 2016. And while the Supreme Court has not directly confronted a ban on lobbyist bundling, it is also likely constitutional. Such a ban does nothing to affect the rights of individuals to make political contributions. It simply requires that contributors send their checks directly to candidates instead of allowing lobbyists to peddle such contributions for influence and outcomes. Paid lobbyists have chosen a profession that focuses on influencing legislative action. Because such a career inherently carries an increased risk of corruption, a simple restriction that prevents lobbyists from benefiting from the contribution choices of others is common sense and narrowly tailored. Expanding revolving door restrictions. Currently, members of the House and employees of the House who are paid at least 75% of a member's salary are prohibited from lobbying Congress for 1 year after leaving government service. This restriction also applies to former senators for 2 years, to Senate employees who are paid at least 75% of a member's salary for 1 year, and in a more limited fashion to Senate employees compensated at a lower level. Under current law, former members of the House and Senate and former congressional employees may freely aid or advise clients on how to lobby Congress in a background role or freely lobby the executive branch. The AACA extends the existing revolving door restrictions to 5 years for former members and former congressional staffers, and brings all lobbying activities, even acting in a background or supervisory role, within the prohibition. Constitutionality. There is little doubt that these expanded revolving door restrictions are constitutional. Such restrictions on post-government employment have been upheld on various occasions by various courts, because such laws prevent government employees from being influenced in the performance of public duties by the thought of later reaping a benefit from a private individual. Brown v. District of Columbia Board of Zoning, 1980. See also General Motors Corporation v. City of New York, 1974, United States v. Nasser, 1973, and United States v. Conlon, 1980. Curbing the influence of federal contractors. Existing law prohibits federal contractors from making contributions to federal candidates, political parties, and political committees. The AACA extends this prohibition to the federal contractors, PACs, lobbyists, and employees who engage in or supervise lobbying. Constitutionality.
The existing prohibition on contributions from government contractors was upheld by the U.S. District Court for the Southern District of New York in Federation Election v. Wainston, 1978. And was recently upheld by the U.S. District Court for the District of Columbia in Wagner v. Federation Election, 2012. The Wagner decision has been appealed to the U.S. Court of Appeals for the D.C. Circuit. It is hard to know whether or not the current Supreme Court will uphold the existing prohibition of contributions from government contractors, let alone the AACA's expansion of the prohibition to the PACs, lobbyists, and certain employees of government contractors. The U.S. Court of Appeals for the Second Circuit recently upheld a strict New York City restriction on campaign contributions from persons and entities doing business with the city in Ognebean Parks, 2011, cert denied, 2012. And also upheld an outright ban on state contractor contributions contained in the Connecticut Campaign Finance Reform Act in Green, Party of Connecticut v. Garfield, 2010. Whether or not this provision would be found constitutional become clearer when the D.C. Circuit rules on the Wagner case.
2. Campaign finance. Giving voters more voice with a credit for political contributions.
The AACA empowers individual citizens to become the primary funders of federal elections, through the creation of an annual credit of $100 that registered voters can use to make contributions to the federal candidates, political parties, and political committees that they support. In order to be eligible to receive such credits, candidates, political parties, and political committees must agree to only accept contributions from individuals of no more than $500 per contributor per calendar year, and all contributions from political parties and political committees that are funded exclusively by credits and contributions from individuals of no more than $500 per contributor per calendar year. There is little doubt that this provision is constitutional. The Supreme Court upheld the presidential public financing system in Buckley v. Vallejo, 1976. The credit created by the AACA does not make additional funds available to a candidate who faces a self-financed opponent. Such trigger mechanisms have been found unconstitutional by the Supreme Court in Arizona Free Enterprise Club's Freedom Club, PAC v. Bennett, 2011, and in Davis v. FEC, 2008.
3. Transparency. Disclosing bundling and election spending.
The AACA will require federal candidates to disclose the names of individuals who bundle contributions for the member or candidate, regardless of whether such individuals are registered lobbyists. The AACA also will require any organization that spends $10,000 or more on advertisements to elect or defeat federal candidates to file a disclosure report with the Federal Election Commission within 24 hours of airing the advertisement. This report would be immediately available on the FEC website, and must list each of the organization's donors who donated $10,000 or more to the organization to run such ads. The Supreme Court has repeatedly upheld disclosure requirements, most recently in Citizens United by a vote of 8-1. It is very likely that the disclosure requirements in this provision would be found constitutional. Note, however, that in 2012, opponents of the Disclose Act claimed that the act was unconstitutional. For example, the National Rifle Association claimed that the Disclose Act provisions require organizations to turn membership and donor lists over to the government and would unconstitutionally abridge the right of citizens to speak and associate privately and anonymously. We do not believe that these arguments are valid, but we anticipate that they will be made by opponents of the AACA.
4. Enforcement. Prohibiting illegal super PAC coordination.
The FEC's current coordination regulations permit extensive collaboration between candidates and supposedly independent super PACs. The AACA would amend federal campaign finance laws to more broadly define what activities constitute coordination, such that the current phenomenon of single-candidate super PACs and super PACs with close ties to campaigns would no longer be permissible.
Constitutionality. There is little doubt that tightening the coordination regulations is constitutional. The Supreme Court has variously stated that independent expenditures must be made totally independently, wholly independently, and truly independently from campaigns and political parties. See Buckley v. Valeo, McConnell v. Federal Election, and Federal Election v. Colorado Republican Federal Campaign Committee, 2001, stating that independent expenditures must be made without any candidate's approval, or wink or nod. Bringing the FEC's regulations closer in line with these statements of the Supreme Court is very likely to be upheld, if challenged. Calling all lobbyists lobbyists.
The AACA will expand the definition of lobbyist to include every person who, for compensation, 1. makes 2 or more lobbying contacts or who provides strategic advice or directs or supervises lobbying efforts, and 2. spends more than 12 hours on lobbying activities on behalf of a client. The AACA will broaden the definition of lobbying to include the provision of strategic advice and assistance with earned media related to legislation or legislative issues, polling related to lobbying goals, and advice on the production of public communications related to lobbying goals. The AACA also will require the clients of lobbying firms to register and file disclosure reports, and will require registrants to identify the funders of their lobbying efforts. Finally, the AACA will require lobbying disclosure reports to include more detailed information about lobbying activities, such as the specific congressional offices, committees, subcommittees, and members contacted.
Constitutionality. There is little danger that the task force or the interim changes to the FEC would be found unconstitutional. With regard to the provisions incorporated into the AACA from the Public Corruption Prosecution Improvements Act, some have expressed concern that certain aspects of the Public Corruption Prosecution Improvements Act may be unconstitutionally vague. C.D. Michael Kreitz et al., A Congressional Meat Axe? New legislation would broaden the potential for prosecutions under the Federal Illegal Gratuity Statute, 36J, Legis 249, 261, 2010. To be sure, the Public Corruption Prosecution Improvements Act does broaden the scope of the Federal Honest Services Fraud Statute, Gratuities Statute, and the Bribery Statute. These broadened statutes are highly unlikely to be found unconstitutional on their face, but it is possible that they would be narrowed somewhat in their scope as they are applied to the facts and circumstances of particular cases. Anticorruptionact.org
Professional Translation Services GUT